Hi, everybody. My name is Zara. I'm an appellate attorney in New York. I handle appeals in state, federal, and immigration cases. Today, I want to share another one of my pro tips. I've written dozens of appeal briefs at this point, and I see a bunch of different common issues that happen in different appeals, and I collect them in my mind so that I can share them with litigators who are advocating for their clients in the motion and trial courts in order to help them set themselves up better for an appeal. And the tip I want to talk about today has to do with an order that is positive for your client. It's something that you've gotten good relief for your clients on a motion. And the other side, the other party, has brought an appeal, and now your client has to defend the appeal, defend the order in the appeal. And it has to do with kind of a funny version of orders in New York, which are the handwritten orders. It doesn't happen all the time. It doesn't happen in really complex cases. Have not really seen it in the commercial division cases, but I have seen this in a lot in Kings County. I've seen it from Queens County. I've seen New York County. I've seen it from the Bronx. Have not seen it from Staten Island, but I'm pretty sure that they also do it. And it's the type of order that is a blank form that after you have oral argument before your judge makes the decision from the bench, which is good. You already have the decision, and the judge says, write me up an order so that I can sign it. Now, the one who won the motion generally gets to write up the order. So that's you. So that's good. You have control over what goes in that order. Now, here's an issue that sometimes comes up. You have, and I'm going to actually illustrate it with a case that I recently worked on where this issue was a real problem. The case was a foreclosure case, and the foreclosure proceeded to a judgment and to even a sale. They had a sale at an auction. And the defendant made a motion after that sale, after the auction, to vacate the sale so that he could put in a defense to the foreclosure. Now, this defendant was not the lien holder. It was someone who had an interest in the property who actually wanted to redeem the property by paying off the lien. Now, they didn't ask for that in the motion papers. They were just trying to vacate the sale in the judgment. And the judge actually, instead of vacating the sale in the judgment, the judge granted conditional relief of allowing this defendant to pay off the lien. Otherwise, the sale would be closed. So this was great. Goes up on appeal. And the problem in this one was that the written order, so the defendant who got the relief had an order that didn't have any details in it about what the judge's reasoning was for granting relief that wasn't actually requested in the motion. So when it went up on appeal, it was a little tricky because it isn't clear in the law whether this should have happened. The relief should have been granted in this order because you're technically after a sale, the foreclosure is over and the party can't redeem. But there is a little gray area in between there where the court can exercise authority to allow a defendant with an interest in the property to redeem the sale. And that's what happened here, but it wasn't explained in this order. So I found the best arguments that were possible for this issue. And I do think the judge had authority to do what he could give the relief that he gave, but it wasn't explained. So it's going to be very difficult for the appellate division to affirm this order. Now, I just did the oral argument a few weeks ago. Haven't heard yet. I'm suspecting that the appellate division is going to have a little bit of a problem with it. And so we'll see. But a way to avoid this problem altogether is to make sure that when you get to handwrite an order and the judge granted relief that you didn't specifically request in your motion papers, that you should write out the reason for the judge's decision. Now, also, you want to make sure you think quick on your feet and confirm what the reason for the judge's decision is while you're still in front of him arguing, so that when you go off to write the order, you can write it accurately. Okay, well, I hope that helps some of you. And I have other pro tips for different issues that I see as an appellate attorney. You can check them out on my website, www.onpointexpertise.com/interest points is direct to my blog. And I have other videos and blog posts there about these different issues. And I hope they help. Thanks for watching, and I'll catch you next time.